Hello, everyone. I'm your host, Andrea Weckerle, and welcome to the Ready Living podcast, where each episode is designed to educate, inspire, and empower you to create the life you want. Thanks for joining us, and remember to subscribe for free on your favorite platform. My guest today is Spencer Cantrell, a national expert on gun violence prevention and extreme risk protection orders. She is co-lead of the National ERPO Resource Center at the Center for Gun Violence Solutions within Johns Hopkins University's Bloomberg School of Public Health. Prior to Johns Hopkins, she worked for over a decade in victim survivor services, most recently as the legal and advocacy director at the Greater Washington Jewish Coalition Against Domestic Abuse, where she managed a team of attorneys and advocates to represent and assist survivors of domestic violence and sexual assault. She also worked on policy at the state and local levels. Spencer has a bachelor's degree from the University of South Carolina in International Global Studies and Women's Studies, and a Juris Doctor from George Mason University's Antonin Scalia Law School. Welcome, Spencer.
Thank you so much for having me. I'm glad to be with you today.
The United States has the most heavily armed civilian population in the entire world. About 4 in 10 U.S. adults say they live in a household with a gun, including 32% who say they personally own one, according to Pew Research Center. And the stakes are high. Pew reports that around 44,000 people died of gun-related injuries in the United States in 2024, a number that includes both homicides and suicides. And those are the raw numbers. But behind every statistic is a person, a family, a community, and for far too many people, the threat of violence isn't abstract. It's happening inside their own home or in their community. So today's episode is going to share information about what people can do if they or someone they care about is living with or connected to a person who is dangerous and has access to a gun. But before we get into the specifics, I want to start with you. You've built your entire career around preventing violence and fighting for survivors through direct legal services, advocacy, and now policy work.
Gun violence is an issue that impacts so many people, not just victims of the violence itself, but it has these ripple effects. I got into this work in a somewhat circuitous route. I had the opportunity after college to work in Hong Kong for a year through the Episcopal Church, working with victims and survivors of violence there. I was a victim advocate for migrant domestic workers who were abused by their employers, people that didn't have all of the legal protections that other folks had in Hong Kong. And I was just so struck by the other folks I worked with in Hong Kong and the empowerment model that they used that I knew when I went to law school, I wanted to continue on that trajectory. And so when I got back and was in law school, my first internships were with domestic violence organizations and working in gender-based violence. I did that for many years with different internships and then different jobs. After I'd been doing victim services work, direct services work for over a decade, I wanted to just think about what could I do more broadly, because there were so many times when I would have a survivor in my office or on the phone, and the options that were available weren't enough. The safety planning that we could do wasn't enough. And so I wanted to figure out what could I do to change the ecosystem and make things safer and improve policy and help address gun violence. That's such an important thing to consider when you're working with a domestic violence victim or survivor.
One of the most powerful tools in gun violence prevention is the Extreme Risk Protection Order, sometimes called a red flag law. Can you start by explaining what an ERPO actually is, how it works?
We call them Extreme Risk Protection Orders, or ERPOs. People might have heard them in the news or in the media referred to as red flag laws. Different states call them different names sometimes, like in California, it's a gun violence restraining order. These are civil laws where if someone is making threats or engaging in threatening behavior, every state has a list of factors to consider for their ERPO law. The petitioner can go to court and request that that person have their firearms removed and preventing them from being able to legally obtain firearms for the duration of the ERPO. These are civil orders modeled in large part after domestic violence protection orders that just solely address firearm access. 22 states, the U.S. Virgin Islands, and the District of Columbia have these laws on the books. So more than half of the United States population lives in a jurisdiction with an ERPO law in place. We know that these laws are really impactful. When I'm traveling around the country training folks, I'm constantly hearing examples of how ERPOs have been used. A study that came out in 2024 showed that for every 17 to 23 ERPOs issued, a life is saved from suicide. The research is incredibly promising that these are life-saving civil orders. When ERPO is done well, it's also about understanding what gave rise to that person being an ERPO respondent and getting them the help and supports that they need so that when that ERPO expires or ends, that they're in a better place and in a safe place. It's not just about removing the guns, but also about making sure that people are well and can safely take advantage of their Second Amendment rights.
You mentioned that 22 states have these laws in place. Are others looking at that?
The latest ERPO law to pass was in Maine in ballot initiative just in November of 2025. Their law just went into effect earlier this year. The idea is be proactive. When we see something, we can do something, go as upstream as we can and remove firearms before someone does something to harm themselves or others. I've heard one sheriff and sheriff's lieutenant who runs the ERPO unit in Florida describe it as a timeout between the respondent and their firearms.
Where might this occur?
We've seen ERPOs being used in a lot of different contexts. Domestic violence, but also suicide, and then workplace violence, political violence or threats against elected leaders, threats of mass shootings, threats of school shootings. I've also seen it used some in neighbor-to-neighbor disputes where things have gotten really heated and escalated between neighbors. On the domestic violence and ERPO nexus, when you think about who can file for a domestic violence protection order, it's often the survivor filing. But in an ERPO case, petitioners are law enforcement in every jurisdiction. Many jurisdictions also include family or household members, and then in some jurisdictions, clinicians can also petition. Why I'm saying all this is that in a domestic violence protection order, it's only the victim or survivor that can file. And in ERPO, law enforcement could also file. And this could be good because then it's not on the survivor to file. Law enforcement can do that, especially if we have a survivor of domestic violence who's worried about retaliation or reprisal. They might not feel safe going to court. They might be really intimidated. And so if law enforcement knows about this, then they could file for the ERPO. We know that oftentimes when domestic violence survivors are thinking about leaving, that's a very dangerous, risky time. And we want to make sure that they are comfortable with that ERPO being filed. ERPO is just about firearms. It's just about removing the firearms that the respondent has, preventing them from being able to legally obtain firearms for the duration of the ERPO. In a domestic violence protection order, there's so much more relief included. They include stay-away orders, no contact orders, possession and use of the home, potentially temporary child custody. ERPO is solely focused on firearms. The domestic violence protection order has much more robust relief. And so it's just important for survivors to know what their options are so they can make the best decision for themselves.
In the United States, we have due process, the constitutional guarantee that a person can't be deprived of life, liberty, or property without fair legal process. How is due process actually built into the ERPO system?
That's a great question. Extreme risk protection orders have due process both at the ex parte stage when the order is initially filed and all the parties might not be in court, and then also at the final stage. We have decided as a nation through our courts that there are times when it is so prudent to act that all the parties might not be in court and there might not be the same due process protections at the ex parte or temporary stage that there is at the final, because it's just so important to protect public safety. So if someone is accused of child abuse, they can have their children removed before there's been a hearing in order to keep the children safe. And then as soon as practical, within a business day or two, there will be a hearing to make sure that that was the right decision and that there's enough evidence. That's what we have in the ERPO context too. You act, you file, the judge or judicial officer makes a determination whether or not there is sufficient evidence to grant or deny that temporary or ex parte ERPO. And then at the final stage, everyone comes to court after the respondent's been served. Everyone has the right to present evidence. The respondent, like in any other civil case, can hire an attorney if they choose to. There's a whole hearing on the merits of the case. And then the judicial officer decides whether or not to grant or deny that final order. And then the respondent would still have the right to appeal that decision. We have due process built into the ERPO process, just like we do in other civil cases.
So, what are some of these factors?
The ERPO statutes in every state are a little bit different. But first and foremost, the main criteria we see is individuals making threats to harm themselves or others. A lot of the statutes are looking at the totality of the circumstances and how imminent these factors are when deciding whether or not to grant or deny the order. When we're looking at other factors, we're looking at, has the person brandished or unlawfully used firearms? Is there abuse of alcohol or other substances? We know that alcohol is a tremendous risk factor for violence. We know that if someone has violated other court orders, domestic violence protection orders, that is often a risk factor included in states' ERPO statutes. If someone has recently acquired a lot of firearms, that's considered in some states' ERPO statutes, but that in and of itself is never the ground for the ERPO. But I think when you have someone making a lot of threats and then going out and heavily arming themselves, when you look at that conglomeration of factors, you can see that risk level escalating. And so that recent acquisition of weapons, when piled on top of these other factors, is something that when I'm working with threat assessment professionals really grabs their attention as well.
When we're talking about violence or threats of violence, what legally qualifies? For example, does it require a physical contact, a touching, or can it include assault? In other words, a credible threat that causes fear of imminent harm. And what about threats or intimidating behaviors that aren't immediate, but that suggest danger down the road?
It's really going to depend on the evidence and the state statute for how imminent something is required to be. And that's something I talk with implementers across the country about because different judges and different statutes look at imminency in different ways. Typically, what we're seeing is an imminent threat, or sometimes we're even seeing threats to do something on a specific date when violence is more likely to occur. We are often seeing folks threatening to hurt themselves in very vivid and descriptive ways. They're threatening to hurt other people and their family or community in very vivid and descriptive ways. And I have seen ERPOs used in some cases where the respondent doesn't even own or possess firearms yet, but we're worried about the respondent obtaining firearms. And there have been threats. I'm going to get a gun and do XYZ. And so in those instances, the ERPO is really important to make sure that they don't obtain those firearms and do what they've threatened to do.
I would like to walk through the ERPO process step by step.
Sure. There's always going to be a little variation, but generally speaking, the petitioner is the person who's going to file for the ERPO and fill out the forms asking the court to issue an ERPO. Across the country, in over 90% of cases, it's law enforcement that are petitioning for the ERPO. In a lot of these instances, law enforcement might get a call from a family member who's concerned about someone who's threatening suicide. They might be looking at a potential threat case where someone's threatening to hurt an elected official or to perpetrate some sort of mass shooting. And so for whatever reason, law enforcement knows that this person is making threats or engaging in threatening behavior, and potentially have other evidence from other family or household members, the social media. They'll fill out the forms. The petitions are typically a couple of pages long, and they'll file that with the court. And then the judicial officer will have a hearing and determine whether to grant or deny that ex parte or temporary ERPO case. The law enforcement officer will go and say, this is why I think there should be a temporary ERPO. If the judicial officer grants it, then law enforcement, it's usually the sheriff's department, will serve that order on the respondent. That means giving them notice that this case is there and telling them when the court date will be for the final ERPO hearing. In most instances, when that ERPO is served, then the firearms will be removed from the respondent, or they'll be required to hand over their firearms to the sheriff that's served the order. And then usually it's about 7 to 14 days after the temporary or ex parte ERPO hearing that there will be a final ERPO hearing where everyone comes to court, the petitioner and the respondent, and everyone is free to bring an attorney if they choose. In some jurisdictions, law enforcement are represented by city or county attorneys. Then everyone presents their evidence, why there should or should not be an ERPO. People can call witnesses, people can cross-examine the opposing parties' witnesses. And then based on that, the judicial officer, typically a judge, will decide whether to grant or deny the ERPO. That can be for typically up to 1 year. In some states, it might be for longer. In many states, the respondent can also agree or consent to the ERPO and say, you know what, I don't want to have a hearing. I don't want to get into the details of my case, but I will agree to the ERPO for this period of time. I will also just add, before we get to the temporary stage, in some jurisdictions, there's a process to do an emergency ERPO, even on nights or weekends, where if law enforcement are really concerned about someone, then there might be an on-call duty judge who could hear the ERPO in the middle of the night. And then law enforcement could remove the firearms very quickly when there are grounds to do so and there's that need to protect public safety.
You mentioned earlier that in most cases, law enforcement is the one that will file the ERPO, and presumably it's either based on eyewitness or calls or information from neighbors or family members who live with the individual who has the firearms. When it comes to court then, and everybody has opportunity to hear from both sides and examine witnesses, are the people who live in the home, let's say, required then to testify? What happens to law enforcement that has filed the ERPO but themselves doesn't live in the home? Is that enough to justify being able to remove a firearm potentially?
It really depends on practice in the jurisdiction, what evidence is often submitted. I've seen in many jurisdictions that there might be body cam footage from when there was that initial engagement with law enforcement and another witness that could be admitted. I've also seen sometimes where family or household members or school officials or colleagues may be needed to testify and say what they've seen and what threats were present. People may have written something out in social media or via email or left a voicemail. Law enforcement are often looking at what evidence they have and often going with that first before calling in witnesses, especially family and household members, because if you're so worried about a loved one that you're going to call the police, then it's probably going to be really hard for you to go to court and talk about what they were doing. Those family and household members are often better suited to help the respondent get connected to supportive services, help them get into a better place, and not be adversarial witnesses in court.
An ERPO is a civil order, not a criminal conviction. So what actually happens if a respondent refuses to surrender their firearms? Are there any enforcement mechanisms and consequences?
Some jurisdictions are really great and have compliance hearings. And then in some jurisdictions where you might have a license or a permit to carry scheme, then you might know what firearms that individual has or has access to. And they're in some jurisdictions required to also surrender those permits or licenses. But the enforcement piece is often based on knowing what firearms the respondent has or has access to, and then ensuring that law enforcement has that information so that when they're looking at what firearms the respondent has surrendered, kind of cross-checking that with what firearms the family might have said that the respondent has and making sure that they have in fact relinquished all of those guns. Failure to surrender the firearms could be a criminal violation of the ERPO. And so in those cases, it could lead to criminal charges. But I have seen some amazing work being done by law enforcement across the country to talk with respondents and get them to willingly surrender their firearms and say like, oh, you gave me these 2 guns, but I think you may still have a hunting rifle. Are you sure you don't want to give me that as well? And then the respondent goes, oh, you got me, and will comply with the order. But that's also on law enforcement to have their due diligence done when they're going to collect those firearms.
You co-authored a health affairs article specifically examining ERPOs and minors. How does the ERPO process work when the person at the center of it is under 18 years old?
3 states now explicitly include minors as respondents in their ERPO statutes. Colorado just updated their ERPO law earlier this year to include that. In many jurisdictions, you have to be a certain age to purchase a firearm. But we also know that in many, many states, you can be a minor and possess firearms, go hunting with your parents, are around firearms in and out of the home. And so we know in those instances, it's really important to prevent firearm access for minors that are threatening violence. My children are still very young, but I'm always amazed at how even my 6-year-old is able to sneak candy off the counter. I think children and teens are often very savvy about knowing how their parents have their firearms stored, what the code to the gun safe is, where the key for the lock is, and really able to access those. And so when we're looking at these cases, oftentimes the law will include a mechanism for the parent's firearms to be removed in the ERPO case where the minor is the respondent, and then clearly lay out a process like in Michigan and Washington for the parents to get those firearms returned, but making sure that they are stored safely outside of the home where the minor cannot access them. When someone's about to reach the age of majority where they're able to purchase the firearm, in those instances, it's really important to prevent them from being able to obtain firearms. The shooter in the Uvalde, Texas, horrible mass shooting, he purchased that firearm within minutes of turning 18. Preventing future access is so critical.
ERPOs and domestic violence protection orders can both apply to dangerous home situations. That's what we talked about earlier. I want to make sure that listeners understand what domestic violence entails and what range of behaviors fall under that umbrella.
Domestic violence, like you said, is an umbrella term for a lot of different forms of abuse. It's physical abuse, threats, sexual abuse, including coercion or refusal of safe sex. It also includes verbal and emotional abuse, which is so much more impactful than I think people realize. Controlling finances, blocking access to finances, prohibiting people from engaging in their full economic potential, digital abuse. We also see stalking and then coercive control, controlling what the victim or survivor can and can't do in the relationship. We see domestic violence happening across the board in teens and young adults, in elder abuse. This can happen to men. It can happen to women. It can happen to same-sex couples. And I think there's sometimes this misconception that it only happens to a certain kind of people, but that's not true. I've worked with people across the lifespan, and I've worked with people from all kinds of socioeconomic backgrounds, from all these different professions and jobs, across incomes, relationships, genders, sexual orientations, races. This impacts so many people in so many different ways.
There is a documented connection between domestic violence, child abuse, and animal abuse. And coercive control plays a large role in that as well, keeping a victim survivor trapped. Can you talk a little bit about how that dynamic works?
We know that animal abuse is often a huge risk factor for future violence. We also know that coercive control, like threatening to harm a child or a pet, is something that really keeps people stuck in abusive relationships. When I was still in practice working with victims and survivors, there were so many instances where someone wouldn't or couldn't leave because they were afraid of what would happen to their children or their pet. It's really about controlling them and their actions. And I think we've made some progress as a society to think about where someone could put their animals if they're leaving an abusive relationship. In many instances, judges will think about domestic violence in a child custody context, but there is still so much more work to be done in this realm.
In an earlier Ready Living podcast episode, I interviewed Senior Detective Mark Randall, who, since retiring from the police force, has dedicated himself to exposing crimes against animals. He talks about how, for a lot of survivors, leaving a pet behind is inconceivable. Fortunately, there are a growing number of animal shelters that offer temporary housing for pets from unsafe homes and domestic violence shelters that allow victim survivors to stay there with their companion animals. And I would encourage listeners to check out Red Rover. That's one place, redrover.org, and Safe Havens for Pets at safehavensforpets.org as well for more information about that.
Amazing resources that are just so impactful.
One of the most important things someone in a dangerous home situation can do is create a safety plan, even if they're not ready or able to leave. Can you explain what a safety plan is, what it typically includes, and why it matters even before someone has decided to go?
A safety plan is a really dynamic, survivor-centered plan where you think about holistically what needs to be done to keep that survivor safe. And so it's thinking about if they're going to leave, what steps need to be done to keep themselves and their children safe. And going back to the different kinds of abuse, thinking about their physical safety, their emotional safety, safety from economic abuse, safety from stalking, thinking about the whole spectrum of coercive control and what needs to be done to keep someone safe. Thinking about if they're going to leave, what would they take with them and where can they put that so they're ready to go? How would they physically get out of the home? What is an escape route? Are there code words that they might want to have for family or friends if something does happen? Letting the right people know that they might be leaving, keeping that circle small, right? But thinking about who can they confide in to help them if they are going to leave. Where would they go? Thinking about what do they need if they're going to leave? What can they do to prevent themselves from being stalked? Not to put the onus on the victim or survivor, but just making sure that we're helping them take those steps to think 360 degrees about their safety and those of anyone that might be leaving with them. And sometimes an ERPO or a domestic violence protection order might be a part of that safety planning. But I would encourage folks, if they're in an abusive relationship or experiencing any kind of intimate partner violence, to contact a local victim advocate where they live. They could contact the National Domestic Violence Hotline to be connected with resources because there's so many nuances in a jurisdiction about what you can file in what courthouse or which commissioner's office. And then just knowing what resources or shelters are available to you when you're going through this horrific time.
The National Domestic Violence Hotline, they have a free online safety plan tool that people can check out as well. What happens if the victim survivor is not a U.S. citizen?
There might be relief available to survivors of intimate partner violence or domestic violence who are immigrants to help them with the really challenging nuances of their situation. There are special visas for people who report crimes and cooperate with law enforcement and prosecutors. There are special visas for victims of human trafficking in this country. The backlogs for the crime victim visas are dreadfully long. There are also protections sometimes for victims of domestic violence who are married to U.S. citizens. And so there can be protections in those instances. But we know that when we're looking at coercive control among immigrant victims of domestic violence, that it might look a little bit different. It might include threatening to call ICE on that individual. It might include withholding their passports or immigration documents or just weaponizing their immigration status against them. It's really challenging for immigrant survivors to access the needs and services required to leave an abusive relationship because of this fear and the coercive control based on their immigration status. But there are some amazing resources and service providers available to immigrant victims and survivors of domestic violence who can really help making sure that they're able to access services in their primary language and get as much support as they can.
How do ERPO and domestic violence protection orders work together? For example, if an ERPO is already in effect and a domestic violence protection order is later issued involving the same respondent, are they both active simultaneously?
They would be active simultaneously. Sometimes you might see more than one order entered against the same respondent. When I was still a practicing attorney, I know I represented a victim of domestic violence in a protective order case where law enforcement also sought an ERPO against that same respondent. And so there were these concurrent orders that applied to the situation. The respondent was also threatening self-harm. And so based on that, the grounds for the ERPO were different from the grounds for the domestic violence protection order, but they both served the same purpose at removing firearms.
For someone in the middle of any of these situations, it can surely feel overwhelming, but I want to end on a note of hope because the whole reason we've been spending time talking about the law, the process, the protections is that tools exist to help people that have saved and continue to save lives. So if someone is listening right now who recognizes a situation, maybe their own, maybe from somebody that they love, what do you want them to know?
If you're worried about someone you love, if you're worried about them hurting themselves, 988 is an amazing resource where you can get support for yourself and think about how to best support that loved one in your life who's threatening to hurt themselves. When law enforcement are looking at ERPOs and other cases where people are threatening to hurt other folks, law enforcement can only act based on the information that they have. So in those instances, calling law enforcement or calling 911. And if you live in a jurisdiction with an ERPO law, you might be able to petition as well, just to put some time and space between someone threatening to hurt themselves or others and their guns can just be so powerful in preventing harm.
Where can people find out more about your work?
We have a website for the National ERPO Center. It's erpo.org, ERPO.org.
Spencer, thanks so much for taking the time today.
Thank you so much.